Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here with you each and every Sunday at this time on this station to bring you, the landowner, the information that you need regarding natural gas development. And of course, and as always, I do not, and I, Doug Clark, will not, never have, never will represent an oil or gas company. I represent the Pennsylvania landowner, property owner, royalty owner for such items as, and there's a long list, natural gas leases, oil and gas leases, pipeline agreements, water line agreements, well pads, royalty issues, royalty deduction issues, unitization, breach of contracts, any surface use agreements, well pads, meter pads, you name it. If you have an oil and gas issue, you give us a call, Clark Law Firm, 570-307-0702. That's 570-307-0702. See if we can help you out. I think we can. Also, just as I have to always say this, multi-unit wells. Multi-unit wells. Wells that are going to go from one unit and continue and go on into a second and third unit even in many cases. Multi-unit wells. If you are given a document, it's usually entitled a consent, but be careful. Companies are smart. They'll change titles to these documents. A consent to multi-unit well request. I implore you, call me or call somebody who knows what they're doing, who's negotiated these and has dealt with these. Call, get a review and consultation, find out what, if anything, find out what can be done to try to make this better for you. Do not leave potential benefits on the table because you didn't call. Call. Reviews and consultations for multi-unit wells usually take an hour or two, and I really think you're going to be pleased if you call the Clark Law Firm, do a review and consultation, and I'm saying this not because I have no work. I'm saying this because I really believe that I can help people in that situation. You give us a call, do a review and consultation, and I'm pretty confident I can help you out. And the worst case scenario is you'll have all your questions answered and you understand everything, and you'll make the right decision whether to sign, whether to negotiate, or whether to pass on the agreement. But you will not have that information if you don't call me or someone who knows what they're doing in these, who've negotiated these. Not someone who's just looked at it before, but somebody that's interacted with the companies. Call Clark Law Firm, 570-307-0702. 570, and it's so important, and that's why I keep hammering on this. 570-307-0702. I want to help you. I want to help everybody that has this situation in all situations. So give us a call. Also, I got to say, I have to keep saying it, Tioga County. These vertical wells that are capped and have been sitting there for years and years, most of them drilled 2010, 2011. I want to hear from you if you have been shut in, especially 7 years, 8 years or more. I really want to hear from you because we need to do something about it, and we're going to take action, and we're in the process of doing that. So I really want to hear from you. Give us a call. I'll look at this information. We want to see if you have a potential claim because in my book, this is outrageous. This is outrageous, and we need to do something about it. So give us a call on that as well, 570-307-0702. Sorry to be so commercial, but I'm telling you, I really want to hear from anybody who's in a shut-in situation in Tioga, especially 8 years or more. And then I also really want to hear from multi-unit well consent people because I think I can help you, and I want to help you. And, of course, any other areas, I think I can help you too. However, I'm stressing these multi-unit well consents especially because a lot of people have them in hand. A lot of people are signing them. And before you sign, I really encourage you to give us a call. Okay, let's have some fun. Let's have some fun. And what's fun? Well, to me, I enjoy pointing out what I think are atrocious terms in contracts that are presented to landowners. I like to point this out because I like people to be aware, not only in this particular case about what this language is, but I want people to be aware that maybe you'll never see this language. But I'm going to tell you, the language I'm going to talk about, it's not like this is in a vacuum, that there's only one company in the United States who's presenting such language or agreements to people. And what I mean by that is when you listen and you hear language and you say, wow, really? A company's really doing that? Or they're really including that language? Well, please think that maybe an offer that you're going to receive in the future may have that same or similar type language. That you say, wow, what company would ever do that? Well, that may occur to you in the future. It may have already occurred. You may have already signed this document or a document that had language like this. But the point is to illustrate that some of these agreements and some of the terms in all different types of agreements are so one-sided and so company-friendly that if you really understand them, you're either going to do everything you can to change it, or you're not going to agree to that particular agreement, or you're going to wait to see if something improves. But the key is you have to be aware that some of these agreements, and many of them, now I'm not saying they all have this exact language I'm about to talk about, but these agreements tend to be heavy-handed in favor of the company. So let me explain. Let me explain what I mean. So, Eclipse offer. So listen, guys, here you go. This, again, is not specific advice for anybody, but it's general information to put out there. Well, here's some good, really, really good general information about this Eclipse royalty provision that they are offering landowners, Tioga, Potter County area. But again, I don't care if you're in Washington County or Susquehanna County or anywhere in between. This type of thing, this type of language is out there. And it's not just limited to one area. And yeah, it's not identical everywhere, but you're going to hear that, whoa, if any of this language is in my lease or the lease offer I receive in the future, I need to be aware of it. And I need to try to change it. Or this may not be the right agreement for me. Especially imagine if you're only getting 12.5% royalty. But I don't want to focus, the percentage of royalty can be really quite the trick, where company says, oh, we'll give you 15% royalty, but they'll take deductions like crazy. It'll take every deduction under the sun, where you would be much better off to have 12.5% royalty, but a better royalty calculation method. And we know that there's these buzzwords of deductions, but how many times do I say it? These companies are smart. So, deductions, loophole. Well, now everyone's aware of deductions. So, how else can we create loopholes? Well, how about we use affiliated sale transactions, where we sell the gas to another company that we've created that we own. And then we price the gas in a certain fashion based upon the transaction, where we, as the producing company, sell the gas essentially to ourselves. Not good for you. Not good for you. So you need to now understand all about deductions, which I'm going to tell you the vast majority of people who I speak to believe they understand about deductions, but after we do reviews, consultations, have discussions, they didn't quite understand about deductions the way they thought they did. Then we throw in affiliated sale transactions, where the company sells the gas to another company the first company owns. Then we talk about, can they use what's called index pricing, the average daily price from a local index point where the gathering lines connect to the interstate pipeline? And will that be permissible under your agreement? And is that something that you're agreeable to? It's important that you understand these things, and then you negotiate and try to eliminate or minimize their impact on your agreement. You're listening to Attorney Doug Clark. This is All Things Marcellus. Join me each and every week at this time on this station. And so, okay, I want to jump into this now. So this is a lease, a form of a lease, and this one here is actually blank. It doesn't even state the oil or gas royalty percentage, meaning like 12.5. By the way, and as always, the state minimum in Pennsylvania. So anytime you have a 12.5% gas lease offer, you should be thinking, I can't do worse than 12.5%. Then we look at, how are the royalties going to be calculated? Let me just say, basically speaking, a lot of people may think, okay, gas comes out of the ground at the well site. It's transported from the well site through pipelines, and it gets to the point where it is now sold to another party, another company. So your company produces the gas, takes it out into the market and sells it, and let's say they sell it for $2. Well, many people would think, okay, my royalties will be based on $2 for gas, $2 per unit of gas. However, the deductions would be, you sell it for $2, you deduct or subtract the costs that you have or you've incurred to get that gas to the marketplace. So if the landowner's share was 50 cents in deductions, well, then you take $2, you minus 50 cents, and the landowner would be paid royalties based on $1.50 gas. So 50 cents out of the $2 would be taken in deductions. Now, that example, that gives us essentially, like, we're talking about pipeline costs, transportation, maybe some compression fees, and that's what we've normally seen. And that's what we've generally seen is these wells are producing and royalties are paid. But again, companies are smart and companies are getting creative. So in this particular lease, the gas royalty is just literally one sentence to say gas. To pay the lessor, being you, the landowner, on actual volumes of gas sold from the land, an amount equal to, and then it's a certain percent, in this case is blank, it says of the net amount realized by lessee computed at the wellhead. So let me explain. So that's kind of like what I just explained to you, or what I just said earlier, where gas is produced, company takes the gas, pipes it out, sells it at the marketplace, and now in order to determine the wellhead price, if they sold it for $2 and there was, we'll say, 50 cents in fees to get the gas from the wellhead to the market, well, the value at the wellhead then would be $2 sell price minus the 50 cents in transportation fees would be $1.50. So the wellhead value would be $1.50. Now, that's normally a typical classic case of a deduction lease, a lease allowing for deductions. So in that case, like we just see here, the gas royalty provision, which is really, really short. It is literally one sentence. I'm going to read it again. To pay lessor, which is the landowner, on actual volumes of gas sold from said land, an amount equal to, and I'll say 12.5%, but it's blank in this case, an amount equal to 12.5% of the net amount realized by lessee computed at the wellhead. So again, normally we would think that to be sell the gas at $2, your transportation fees from the wellhead to the sell point were 50 cents. So the value of the gas at the well would have been, in that example, $1.50. And so your royalty would be calculated at gas valued at $1.50 instead of $2. When we get back, I'm going to then read to you the definition section, which follows the gas royalty sentence that I just read. Now, the definition section is its own special section. And I'll tell you this, it's not one sentence. It's quite long. And you would need to really bear down and read this and understand it to really appreciate the exposure to deductions that this lease provides to the company, exposing the landowner, royalty owner, to deductions. It terrifies me. It terrifies me. And as you know, and as I say, and I hope you know, that you get the double whammy where companies give you this very bad royalty calculation language and the license to take extreme deductions, in my opinion, and then they mandate that you have to go to arbitration and you have to do your case individually. And when you go to arbitration, even if you win, you don't set precedent, meaning other people can't say, hey, look what happened to Mr. Smith. He won an arbitration and he had the same issue, therefore I should win as well. Arbitration doesn't work that way. Divide and conquer. Go to arbitration 100 times, win 50, lose 50. Well, you still won 50. Go into court, lose the first case, set precedent saying that you were wrong. The next 99 cases use that precedent and company has a problem. So what do? Smart company, shift, say we got to go to arbitration. Well, how's a landowner ever going to agree to that? You're sitting here, you're a landman. Well, hey, boss, how's anyone ever going to agree to that? Well, you tell them it's good for them. You tell them it's good for them. It's quicker. There won't be appeals. It's good for you. Well, Mr. Landman, well, Mr. Company Man, well, Mr. Company, if it's good for me, if it's good for me, you're not going to mind if I scratch it out, if I delete it. If it's in there for me and it's so good for me, then I'm going to take it out. Well, we can't take it out. Why can't you take it out? Why won't you take it out? You can. Why won't you? Because you know that that's your benefit, that you have a license that, well, let me watch my language. This is all my opinion. But what it is we know that now you can push that royalty deduction language to its brink, and you can come into it using extremely favorable royalty deduction language, push it to the brink, and your chances of being sued in arbitration, which is very expensive and doesn't set precedent, are really, really small. So you whammy them once with a bad royalty calculation provision, and then you insulate yourself with an arbitration provision that in many cases guarantees virtually from a practical standpoint that you could be, but you won't be sued. You won't be sued. Take this from today. There's many things to take from today. Arbitration, bad. Arbitration, bad. Remember that. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station, looking for representation, information about representation. Give me a call. Call the office, 570-307-0702. Multi-unit well consents. Shut in for 8 years or more. Call 570-307-0702 and any and all other oil and gas issues. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each and every week at this time on this station for All Things Marcellus. And you can go, if you miss any of today's show, if you've missed any shows in the past, and by the way, I have been doing this show since 2010. I have been doing All Things Marcellus since 2010. If you're not going to my websites at pagasleaseattorney.com and pipelineattorney.com, I'm going to have to assume you don't have a computer, because you can go to those websites, get information, again, as always, that's general information, but get information, pipeline agreements, pipeline leverage issues, buying and selling oil and gas rights, unitization issues, frequent asked questions, all kinds. Use these websites as a resource. And of course, this week's show will be up Monday morning, and each and every week we put the show up on Monday morning, and you have access to hours and hours and hours of radio show. And you want to talk about something riveting and exciting, go listen for 10 hours to All Things Marcellus, and you're going to have an awesome day. But in all seriousness, use the websites as a resource, whether you ever call, and I hope that you do, and I hope I can help you. But if you don't, go to the websites and use them as resources. Use them to get you thinking. What should you be looking for? Listen to prior radio shows. We need to get information out to people. And that's the goal. And certainly, I want to help people. I want to represent people. This is what I do. But if you never call, go check out the websites. Get information. Be informed. The number one reason that people are being taken advantage of all the time is a lack of information and a lack of education on this subject. You could be Albert Einstein, but if you haven't read these leases and seen how they are interpreted and be aware of the case law, you're not going to know what issues you may face in the future. So we need to get this information to you so you're thinking, you're doing better. We're raising the bar for everybody. We're not signing $5, $10 pipeline right-of-way agreements. We're just not going to do it. We're not, because we understand that people are signing baseline 30 in Susquehanna County, baseline. That people are signing $50, $60, $100 pipeline agreements depending upon their circumstances. We're not going to sign ratifications because we know that it's probably a setup. Ratification may be a setup. If you have a lease amendment and modification, ratification, if you see the word ratification, if you see amendment, you see modification, put the pen down and pick up the phone. Ratification is extremely powerful. If you are ratifying your lease, especially if it is an older lease, boy, I would like to talk to you, because I am seeing ratifications, which to me are clear to revive a lease that is terminated. And let's give an example. If you have 100 acres and your lease is terminated and you're given a lease amendment, modification, and ratification, you may revive that lease. So they don't have to give you a new lease, and you sign this document. And I've seen people sign these documents for literally $0. And if the market in your area is $3,500 an acre and you signed a ratification when you really didn't have a lease, well, you just lost. If you have 100 acres, you literally just lost $350,000. $350,000. That's a lot of money. And then you also would have lost your ability to negotiate a better lease, maybe higher royalty or better royalty calculation language. But people are just signing these, and we got to stop it. And the only way we can do it is get this information out there to explain that the person who's presenting you with this ratification, multi-unit well consent, leases, pipeline agreements, work for the company. They do not work for you. Their job is not to help you. Their job is to help the company. That's who they represent. They don't represent you. So we need to take care of ourselves. Do you think a Fortune 500 company is out there to take care of you? And if you think, oh, look, this guy, he's crazy, whatever, go on. I mean, look, talk to anybody. Talk to people that say, oh, boy, they told me it was never going to go any higher, and then it went 10 times higher. They told me, my favorite, this is all we'll pay, and then they paid 10 times higher. It's time and time again. This is a lease with no deductions. Then you get deductions. And the guy or lady who told you this was a lease for no deductions is long gone. They're long gone. And you're sitting there saying, well, they told me it was a lease with no deductions. Well, you know what? Let me give you an example of something. I'm going to get to this lease stuff for a second, but that just made me think of something. So, okay, I'm going to read to you something which gives you an idea. Now, I'm going to say, I'm talking about a landman saying to you, oh, this lease means no deductions. So a landman says to you, this lease means no deductions. And then you sign the lease. Well, what if the lease has language in it and agreements do? And I'm not saying this is exactly an oil and gas lease offer, but they have similar language to this many times. But this gives you an idea. This is coming from a contract. It says that landowner acknowledges and represents to the company that the landowner is not relying upon any additional statement, act, conduct, omission, or event attributable to the company, known or unknown, in entering this agreement. No agent, employee, or representative of the company has any authority to bind the company to any affirmation, representation, or statement outside of or in conflict with the stated terms of the agreement. Let me say that again. No agent, employee, or representative of the company has any authority to bind the company to any any affirmation, representation, or statement outside of or in conflict with the stated terms of this agreement. And landowner hereby acknowledges and represents that the landowner has not relied upon and will not rely upon any such affirmation, representation, or statement, or any any act, conduct, omission, or event attributable to the company. In other words, whatever a landman, company representative, or anyone told you, it doesn't matter if it's not in this agreement. So the language in the agreement is what controls. So landman says, oh yeah, this means no deductions. This means no deductions. Then here you go, a couple years later, 5 years later, maybe longer, you get royalty checks and you see 50% of your royalty check was taken in deductions. And you say, well, there must be a mistake. The landman told me there were no deductions in this lease. Well, number one, go back and see if you can find any of that in writing, because there's a good chance you won't. And so if a landman tells you there'll be no deductions, ask him to put it in writing, ask him to send you an email, ask him to write a letter, ask him to sign it, ask him to give you that information, and watch what that person does. Watch what they do. So if a landman says, hey, this means no deductions, later on you get deductions, and you signed an agreement that had this type of language in it that essentially says, listen, whatever anybody told you, you agree means nothing if it's not in this language, in this agreement. So most people are not reading these and understanding these contracts and are saying, well, here's what the guy told me they're going to do. And then what you hear later on is, well, a couple things. Plans change, things change. All right, that's one thing. And then also, well, I don't know what to tell you. Your lease allows for deductions. You signed it. Oh, by the way, you should have gone to a lawyer if you had questions, and you didn't do that. Well, maybe even the person said, you don't need a lawyer. But regardless, that's your own fault. That's your own fault if you sign these documents and you don't understand them and you get taken advantage of. And we got to stop it. And that's, again, the point. We have to stop it. We have to stop it. And it can be stopped. It really can. It can be stopped. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here with you each and every week at this time on this station. You can check out pagasleaseattorney.com. Check out pipelineattorney.com. Think about it. If you have a pipeline offer and you are not going to pipelineattorney.com, why not? Because you want to know less, because you want to do worse, because you don't care about the property, you don't care about maximizing money, you don't care about limiting the impact of your property, you don't care about future generations. Well, no, those can't be any of the reasons. So go to pipelineattorney.com. You like what you see, give us a call. See if I can help you, regardless of your location. I've worked on pipeline agreements involving 70-plus different companies. 70-plus different companies across Pennsylvania, all over Pennsylvania, all gas-producing areas of Pennsylvania. So give me a call, see if we can help you, understand your leverage. Real quick, I am so tired of hearing. I am so tired of hearing companies saying to people that the company has the right to install this pipeline under the terms of the gas lease. And in my opinion, in many of these cases, it's not true. And what happens is people believe what they're told by the other side who wants them to sign a document without understanding. Think about it. Why are you asked to sign this document if they can just do it anyway? Well, the response is, well, we're really good guys. We just want to give you free money. We're all about free money. Here's free money. Here's free money. Yeah, think about that. Think about it. If you are presented with a pipeline right-of-way agreement, you need to have counsel. You should do at least a review and consultation. You need to understand your rights and your leverage and then decide how to go forward. I can't stress that enough. I'd love to hear from you regardless of where you are, but these pipeline agreements can really be negotiated for money and minimizing the activity and the rights of the other party. And if you're not doing that, you're really making a mistake. You really, really are. We got to stop that. You're listening to All Things Marcellus with me, Attorney Doug Clark, again of the Clark Law Firm. Give me a call, 570-307-0702, 307-0702. Keep listening each and every week at this time for All Things Marcellus. I'll be right back. And I hear, I've been told that these commercials are really interesting, so pay attention. You probably get a great message here. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each and every week at this time on this station for All Things Marcellus. And also, you can call the office, learn about all the different services, any and all oil and gas matters, reviews, consultations, multi-unit wells. If you're shut in for 8 years or more in Tioga County or anywhere, give us a call. I want to hear from you. 570-307-0702, pipelines, you name it. Give us a call. See if we can help you. Again, regardless of location. I have clients all across Pennsylvania. Love to hear from you and see if we can help you out. Okay, talking about this Eclipse lease offer, I'm really tuning in on this deduction language or royalty calculation language. And again, you may say Eclipse. Well, what the heck do I care? I don't have an Eclipse offer. My point is that you need to be aware that these are the type of offers out there. And I'll tell you, I'm talking about gas leases, but if it's pipeline agreements, you need to understand how bad some of these agreements are. The other day, I had a client where they were presented with an amendment, and the deal is that the company, accidentally, they put something above ground in the pipeline right away that is not allowed to be there. So in order to correct this, they asked the person to sign an amendment. And, say they offer no money. And they say, yeah, we put something above ground. Sorry about that. We offer an amendment. So you sign that and you allow for that to be above ground. Well, now you have increased liability. Remember, you negotiated to have nothing above ground in the past, but maybe for some unknown reason you're willing to do that. Well, in this case, what was presented as the amendment not only allowed what was supposedly accidentally installed above ground, but it allowed unlimited other above ground facilities in the easement area. And how about this one? And adjacent to the easement area. So what was understood to be, okay, if I sign this, it will just allow this above ground structure facility to be on my property, to actually, if you sign it, not only does it allow this above ground facility on your property, which should have never been there, it allows unlimited new and other above ground facilities for no money. It also allows above ground facilities not only within, say, a 50-foot easement area, but also adjacent to the easement area without a limitation of size. So literally, the company could come in and say, we're going to put a 1 acre metering site or a compressor booster, some type of compression or whatever else they want to put. And we're going to take 1 acre. What if they take 2? But it's adjacent to. It's immediately adjacent to the right-of-way. Well, this amendment says that they can do that. When you thought you were going to sign an amendment that would allow the above ground facility that should have never have been there to begin with because you were a nice guy. And now you've agreed to unlimited other facilities, no money, fencing, and actually additional access to and from the property, and operations outside of the easement area, virtually all of which were not permitted previously. That's the type of stuff. That's the type of thing where, reviews, consultations, and in this case, we do review consultations, say, wow, I can't believe this is what's presented to you, and explain it. And the person says, oh, geez, thank heavens, because I just thought I was going to sign this and it just allowed them to keep what they had there. Well, no, it's just not the case. And that's what we have to watch out for. And we have to watch out for this kind of stuff too. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station for All Things Marcellus. So we're talking about the Eclipse lease. Has a gas royalty provision of literally one sentence saying to pay the lessor on actual volumes of gas sold from said land in an amount equal to, we'll say 12.5% of the net amount realized by the lessee, which is the company, computed at the wellhead. So I'm going to read some of these fast, and it's going to give you an idea just how much information is here. And then I'm going to read some of these slow. So the next paragraph is called definitions, and it states, as used in this lease, the term net amount realized by lessee computed at the wellhead, which is from the gas provision I just read, shall mean the actual proceeds received by lessee company. And I'm going to say company instead of lessee. So actual proceeds received by company from the sale of oil and gas after deducting taxes minus post-production cost incurred by lessee or its affiliates after the wellhead. So, contemplating affiliate sales. Red flags should be coming up. Most people probably read this and don't even think anything of it. Next sentence. As used in this lease, the term post-production costs shall mean all costs and expenses of A, treating and processing hydrocarbons, B, separating liquid hydrocarbons from gas other than condensate separated at the well, C, transporting hydrocarbons, including but not limited to transportation of oil from the wellhead to any storage tanks and from such tanks to market, and of gas from the wellhead to any processing plant or other production or treating facilities or the market pipeline to the point of sale. D, compressing gas for transportation and delivery purposes. E, metering hydrocarbons to determine the amount of gas sold or the amount used by the company. Okay, that gives us the E. Okay, let's really now focus, please. F. These are deductions. These are what's included in the definition of post-production costs, so they can be deducted. So number F. Sales, charges, commissions, and fees paid to third parties, whether or not affiliated, in connection with the sale of the hydrocarbons. So the company can deduct the sales, charges, commissions, and fees that they pay to third parties, including their affiliates. So what if their affiliates charge high sales charges, commissions, or fees? What if they charge 5 times what the market really charges? Well, the company gets to deduct those charges. And then what can you do if you don't like it? You can sue them. And where are you going to end up? You're going to end up in arbitration. And that's going to cost you a lot of money. And even if you're successful, you're not setting precedent for any other cases. So people first have to go ahead and sue. They have to then go to arbitration. They have to then win. And even if they win, their victory could not be used by other people. So again, think about this. The post-production cost deductions, that can be deducted from your royalty includes the sales, charges, commissions, and fees that your gas company pays the third parties, including their affiliated companies. So the idea is there's the potential that the company could jack up, the affiliated company can jack up sales, charges, commissions, and fees, which first off are outrageous that they're charging deductions for those. But you're subject to the affiliated sales, charges, commissions, and fees. And I'm going to tell you, in my opinion, that is outrageous. First off, you shouldn't be charged sales, commissions, fees, fees paid, sales charges, and commissions. But yet alone, it shouldn't, I just want to stop there. I wish I could stop there. But it's also with the affiliated companies that those charges can be passed on to you as post-production costs. So don't think just transportation, compression, gathering. Think sales charges, commissions, and fees paid to affiliated parties. So that's F. Then we go to G. Any and all other costs and expenses of any kind or nature incurred in regard to the hydrocarbons or handling thereof by the company or its affiliates after the wellhead. Okay, that's F. But of course, and as often as the case, we're not done. There's a little more, actually quite a bit, but some more to read. Lessee company or its affiliates may use their own pipeline and equipment to provide such treating, processing, separating, transportation, compression, and metering services, or may engage others to provide such services, and if the company or its affiliates uses its or their own pipelines or equipment, post-production costs shall include, without limitation, reasonable depreciation and amortization expenses related to such facilities. Oh, and there's one more clause. Together with the company or its affiliates, cost of capital and a reasonable return on its or their investment in such facilities. Is it a wonder that I am on blood pressure medication? Is it a wonder? Because I'm going to tell you, I care. And this makes my blood boil. We're going to charge you sales charges, commissions. We're going to charge you depreciation costs for us and our affiliates. And we're going to charge you cost of capital and reasonable return on our investments if we use our facilities. And people don't understand it. They don't understand. And that's what I'm saying. If people understood, people may make different decisions. Or you may make the same decisions, but you understand it. And again, this is one example, but this is occurring all over. And as I say, put down the pen, pick up the phone. Put down the pen, pick up the phone, regardless of the agreement. Do a review consultation. Don't sign something and later on see your royalties eviscerated by deductions. Or if you're going to sign, understand what you're signing. Understand what you're signing. And if you don't call me, call somebody who knows what they're doing, who wants to help you. You can call me, 570-307-0702, 570-307-0702. And no matter what, keep tuning in. We're going to keep shedding light on these type of agreements because we need to get this information out there to raise the bar for everybody. You're listening to Attorney Doug Clark. This is All Things Marcellus. Join me each and every week at this time on this station. We got one segment to go. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Got a short segment, so I'm going to jump right into it, but remind you, join me each and every week at this time on this station for All Things Marcellus. Looking for representation, information about representation, give the office a call, 570-307-0702. So I want to talk about, talk about that royalty language. And like I say, even if you don't have an offer from Eclipse, you need to be aware of these things because offers from other companies can be very similar, and also be aware of how these agreements can be very complicated and at times very difficult to understand, and to understand how they may impact you in the future. But I want to talk about, the addendum. Say, okay, well, that gives us some power. That gives us the ability to improve the offer. So in this case, this is a blank document presented apparently to a landowner. And here's some of the addendum terms. So addendum, people think, I got some addendum terms, therefore I did great. I have addendum. Well, again, hopefully we know that it's not just having addendum terms. They have to have value and meaning. And then how are they written? So I'm going to go through some headings and just kind of explain here. So we got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, like 15 addendum terms here. That's pretty darn good. 14, 15. You say, oh man, I got a lot of addendum. Well, let's talk about them. 1, defined terms. Saying whatever term is defined in the lease is the same term in the addendum. Well, that doesn't offer you much value, does it? Number 2, conflict between terms. It says that if there's a conflict between the addendum and the lease, the addendum prevails. Well, that's good, but that's just normal standard language. No storage rights. Company can't store gas. Well, generally, that's pretty darned easy to get and almost a throwaway. We take it, but really not really much value, because I don't know that I've ever asked to eliminate storage rights and the company not agree. So not a lot of value. Same thing, disposal wells. They can't have any disposal wells under the agreement. Again, we're not seeing many disposal wells out there. Not a big deal. We'll take it, but not a big deal. Crop and timber damages. That's the next one. They have to pay crops and timber damage. Does virtually nothing for you, but repeats prior obligations. Timber removal. They will remove the timber. This timber removal provision allows the company to either remove the timber or leave it there for you. If they remove it, they'll pay you an appraisal. If they leave it there, it's yours and they don't have to pay you anything. So boy, that's a really great provision. Well, no, that's what's going to happen anyway. Then we have fences. So they could fence around an area that they're operating, where they're going to almost always do that anyway if there's any type of danger. Again, a throwaway. Gate, they're going to put gates on roads. Again, to me, a throwaway. Surface reclamation and restoration, they're going to restore the surface. They have to do that anyway. Throwaway addendum provision offers you nothing. I love this one. Firearms on premises. Well, their workers aren't allowed to carry firearms on your property. Well, let me ask you this. Are you going to go check them? And what if they do violate? Does that get you out of the lease? What's going to happen there? How are you ever going to know? And if they violate, what is the penalty for violation? I believe no possession of firearms on the property is a total throwaway. Then we get to recordable release. Once the lease is over, they have to file a release at the courthouse to say your lease is ended. Well, shockingly, they have to do that anyway. Again, a throwaway. Then we get to water testing. They were going to test your water if you're within 25 or you're within 1,000 feet of the wellbore. Well, let me tell you, there's a presumption that they have responsibility up to 2,500 feet. So companies will typically test at least 2,500, and many will test much further before they drill a well. They'll test people's water within a much larger distance. So here, talk about a throwaway. They're going to do it anyway, and they only throw in 1,000 feet when the law says that they're presumed to be responsible up to 2,500 feet. So that's 2.5 times what they're offering. My book, total throwaway. Next one, water usage. Can't use the water from your wells, springs, ponds. My book, total throwaway. Pipelines, double ditch method. Well, it's nice to see the word pipeline in there, but they're just saying how they're going to use this double ditch method where they'll put the topsoil on the top, and that's going to only also be in if they put the pipelines in farm and grazing lands. So again, they're going to do that anyway as part of the reclamation process because they have to have the grass grow back up or they can't be released from their permits. Total Throwaway. But landowner says, oh, I got a pipeline addendum. No, you got a throwaway addendum that virtually means nothing. Then there is a payment for a well site fee at a set sum. Well, okay, that's good. We'll take that. So being kind, I'm talking about maybe, one provision out of the 14 or 15, like one of them that has real value. But the person thinks, well, I got this lease offer. I got 14 addendum. By the way, you also have that royalty language we talked about earlier. And you have to understand, in my book, in my opinion, the games that companies play to give you an impression that you have value because you see you have 14 or 15 addendum terms. But when you dig into the addendum terms, you might as well just have blank sheets of paper virtually attached to your lease. Just because you have addendum doesn't mean you have good addendum. This lease, in my personal opinion, is a terrible, terrible lease. I'm not telling anyone don't sign it. I'm certainly not telling anyone to sign it. I'm not giving anyone specific advice. I'm offering my opinion that this is a really bad lease. And unfortunately, it's a lease that people will sign. And it's a lease people will sign because, they're not informed. And there'll be people who, in my opinion, what I would expect, who don't sign because they know that they should be putting the pen down and picking up the phone, that they should be getting more information, getting informed, and most likely, but there's never a guarantee, they're going to enter into better agreements in the future because they were patient and they've learned from mistakes that maybe they've made, and they've learned from mistakes that other people have made. And that's really a valuable way to learn, from mistakes of others, and to use resources. And I'll say, like myself, who have seen other people make mistakes and see how those mistakes have came back to create problems in the future, and how we, in your case, can avoid those mistakes or attempt to minimize any future negative consequence. That's what we need to do. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Keep joining me each and every week at this time on this station for All Things Marcellus, because I'm going to keep bringing it. We're going to keep giving you this information that you need to get you thinking. Always, it's never specific advice, but boy, if this doesn't get you thinking, remember, you are dealing with major commercial industrial contracts for, in some cases, hundreds of acres or even dozens of acres. And I don't care if it's less than an acre. It's still an industrial commercial contract, which very well may last 50 to 100 years. And I deal with leases that are literally 100 years old at this time. So you're talking about contracts that, even if you don't care about yourself, and I really hope you do, but if you don't care about yourself, you got your family, you got children, you got beneficiaries, you have a potential asset that can generate a lot of money potentially for you and your family over time. And things like eliminating or minimizing a deduction may have the consequence of tens of thousands and hundreds of thousands of dollars. Of review and consultation on the pipeline agreement may have an increase of tens of thousands and sometimes hundreds of thousands of dollars. It may not, but it may. So we got to get this information. So I really hope to hear from you. 570-307-0702. And remember, put the pen down, pick up the phone. The landman works for the company, not you, the landowner. Stop signing bad agreements and join me next week for All Things Marcellus at this time on this station. Have a great week, everyone.